Turning to our law and justice lead, an attorney for Donald Trump is responding to new evidence that may undercut Trump's claim that documents he took from the White House to Mar-a-Lago had been automatically declassified when he did it. National Archives officials have informed Trump that they're set to hand over 16 records to special counsel Jack Smith, documents that could show Trump and his team were aware of the correct way to declassify documents, which does not include just, quote, thinking about it, unquote, as Trump has claimed. Here's how an attorney for Donald Trump responded to our news on CNN.
He is aware of a bureaucratic process that can be used, but at the end of his presidency, he relied on the constitutional authority as commander-in-chief, which is to take documents and take them to Mar-a-Lago while still president, as he was at the time, and to effectively declassify and personalize them. He talked about declassifying them, but he didn't need to.
Here to discuss CNN's Jamie Gangel and senior legal analyst Ellie Honig. Jamie, the process that Donald Trump's lawyer described there, is that how it works?
No. You also don't effectively declassify something. There is a process. Yes, presidents have broad authority, but I will tell you, I think former President Trump's lawyer may have just done him a disservice with an admission, again, that he knew how the process worked. Let's just take a look back for a minute, Jake, at how those documents got to Mar-a-Lago. And when they were found, there were hundreds of documents. There was chaos. They were in boxes. When the president's lawyers went to the archives, eventually to find out what was in the boxes, they did that because nobody knew what was in the boxes. So you can't effectively or otherwise, wave a magic wand, think it over, and suddenly all these documents are declassified. It just doesn't work that way.
Ellie, if the special counsel does decide to ultimately pursue charges against Donald Trump in this case, will the defense he's using now, what you heard from Jim Trusty and what you've heard from the president, will it hold up in court?
I don't think so, Jake. I think it's a dubious defense, and here's why. There is a constitutional school of thought that holds that the president is not just the head of the executive branch, he is the executive branch, and as such, he holds unilateral authority to declassify at will, and he does not have to follow any particular checklist or form that may have been formatted by bureaucrats. There's some legitimacy to that. But then it becomes a factual question, which is, did the president actually use that power? Did he actually declassify while he was in office? And to that end, there is just zero evidence that the president actually did declassify. As Jamie said, you cannot declassify by magic or by telekinesis. And in fact, to the contrary, there's quite a bit of evidence that the president did not do any sort of automatic declassification. We've seen 18 different former White House officials who've come forward, some by name, some anonymously, who have said that that claim is, and I quote, laughable, ridiculous, or BS. So it's an interesting theory, but it doesn't hold up on the facts.
And Jamie, you point to several parts of this letter from Trump's legal team that don't add up. Tell us.
So this is a letter that was sent to the House Intelligence Committee by former President Trump's lawyers. And again, this was just last month. They are pointing out in this letter, let me read part of it, that when the boxes were sent to NARA from Washington, that Trump never even reviewed them. So, quote, however, due to other demands on his time, President Trump subsequently directed his staff to ship the boxes to NARA, the archives, without any review by him or his staff. If you don't know what's in the boxes, it's very hard to say you declassified them. There's another part of the letter where the lawyers say we've seen absolutely no indication that President Trump knowingly possessed any of the marked documents or willfully broke the law. Here it goes on. Rather, all indications are that the presence of the marked documents at Mar-a-Lago was the result of haphazard records keeping and packing by White House staff and GSA. President Trump has directed us to immediately notify DOJ of the discovery of marked documents at Mar-a-Lago, and we have faithfully done so. That seems very clearly to be an admission that, oh, we didn't know these documents were there. So again, How do you declassify them if you don't know they're there?
Ellie, the National Archives could hand these 16 documents that are suggested will show that Trump did actually know the classification process, the declassification process. They might hand them over to Special Counsel Jack Smith on May 24th, unless they are prohibited to do so by a court order. Do you think Trump's team is going to try to challenge this in court and bring a court order?
I think they're very likely to do so, Jake, because they've done so in virtually every circumstance that's come up before this. There was a moment in early 2019 when Donald Trump went out to the White House lawn and said, quote, "We're fighting all the subpoenas." He meant it. He has gone to court claiming executive privilege more than any other president in our history. He has lost in court on executive privilege more than any other president in our history. And the reason he keeps losing is because executive privilege is designed to protect legitimate policy and strategy discussions, military, policy, diplomatic, that kind of thing. The Supreme Court has said, generally speaking, the privilege does not keep important evidence in a criminal case out of the hands of prosecutors. And that's why Donald Trump has lost on executive privilege on everyone from Mike Pence to Mark Meadows to the Trump Organization itself. And I think he'll reach a similar result if he challenges this one.
All right, Ellie Honig and Jamie Gangel, thanks so much.